Thanks for joining us for what is part two of our conversation with John Collins, Principal of Black Pearl Private Clients, about estate planning, but also the associated issues of succession and asset protection. So, John, there's an awful lot more to estate planning than just a will. There are things like the powers of attorney and what have you. If you can explain what would they involve?
Yeah, and that's a really good point, James. I think people think about wills being the primary document in their estate plan, but when you go through a holistic estate planning process, you're looking at lots of issues that don't get captured by the will. And some events, while a will is really targeted at, I suppose, a death event in some ways, the other areas that need to be dealt with are life events of incapacity and disability and things like that. So when we work through that, we do look at things like powers of attorney, which are really important. Decisions need to be made on whether they're enduring or not enduring power of attorneys. And enduring power of attorney is one that will continue to operate if you don't have mental capacity and things like that. So that's important.
And there are different types of powers of attorney. Is it medical, general? What do they involve? Do people need multiple?
Generally, most clients that I have will go through the process of doing a financial power of attorney and an enduring financial power of attorney. And they'll also then do, the documentation is different based on states and different terminology around it. And some documentation has been consolidated over more recent years. But the other power of attorney is like a guardianship or a medical style power of attorney that deals with your, I suppose, your medical treatment and the type of treatment you get, but also things like whether you get put into what type of aged care you might go into, and things like that. So these powers of attorney are really important for people who need to manage your affairs if you are incapacitated or
making a critical decision when you're unable to.
Exactly, in a really timely manner without needing to go to the courts, for example. And that's one of the things about even a will. People, a lot of young people might say, and people generally say, do I really need a will? It's the administrative ease that a will creates, and the reduced costs of administering your estate or your affairs, if it's a power of attorney, that are the benefits of having these documents in place.
So if you die without a will, called dying intestate, you are then just going to go through each state's intestacy laws, which, what are the implications of that compared to having a will?
Yeah, exactly. So each state has their own intestacy laws, but they have basically let's call it a formula where there's assets are distributed in a certain order. But they don't, for example, allow you to, if you wanted to distribute or give a gift to a friend or an auntie or an uncle or a charity or something like that, it's unlikely that any of those are ever going to find their way through that mechanism. It's more an immediate distribution to parents and siblings.
It is children. Being able to express your choice and preference.
Exactly. And those intestacy laws don't deal with things like guardianship of children. They don't deal with issues such as your final wishes around being cremated or buried. Now, some of those are enforceable and others are just an indication. But in any event, having those put down in writing and an indication to people is really useful.
We also often hear young families who think, oh, look, I haven't built up a substantial enough asset base to really worry about a will. They keep deferring it, putting it off. That sounds like a risky approach, is it not?
It is. There's a lot of assets that people don't realise that they have either immediately or upon death. So, for example, with wealthy clients, many children, and this is a risk for two generations, have what they call unpaid present entitlements coming from a trust where they've received trust distributions over the years that have never actually been paid. That's an asset of an individual and needs to be dealt with and recognised and understood. The other area that is often missed is that people have insurance through their superannuation, and while you might not actually have many assets today currently crystallised in your own balance sheet, upon death you can realise $100,000, $200,000, $300,000 worth of life insurance that needs to be paid to somebody. And so again, this process looks at that and makes sure that gets paid to the people that you might want it to be paid to.
So in terms of doing your estate planning, if you're in a position such as young person, is there benefit to seeing an estate planning specialist as opposed to going online or your proverbial newsagent?
Absolutely. The going online and using the DIY wills can work. I'm not saying never use them, but they are very basic and simple. They often get filled out incorrectly because it's and terminology is important. So, for example, you need to leave your, when you're leaving superannuation benefits in a binding death benefit nomination, the difference between using the word "I leave it to my estate" versus "I leave it to my legal personal representative" is hugely legalistic, but has different outcomes. So again, involving your financial planner in that process to get the wording right is important. The other aspect to it is just making sure that everything goes through an orderly manner, that you use specialists to get those aspects of it right.
And the cost of using a specialist these days compared to going to the family high street lawyer really doesn't work out to be all that different.
Many lawyers these days have really worked to have very efficient methods to get wills done. So what I would say is, if you're going to get a will done and you're going to get advice, definitely use an estate planning specialist lawyer. There's more and more of them. So I would prefer and would always recommend that clients use somebody who is an estate planning specialist. As you say, a lot of the cost is very equivalent whether you use an estate planning specialist or a lawyer from a local suburban firm. And there's a lot that can be done through that process where they've got templated documents and things like that around testamentary trusts that can be included. They'll ask all of the right questions. I'd strongly suggest that you use a specialist.
As we say to clients, if you're going to have a knee replacement, you much prefer a specialist to do it rather than go to your GP. Thanks very much, John, and thank you for joining us for the second instalment into estate planning. And we'll be again in touch again soon. Cheers.